day, I'm Angie Rosa, a senior labour legal advisor based at SEESA's Durban branch.
Good day, my name is Simone Abrahams, a legal advisor based also at SEESA's Durban branch.
Employers are often faced with negligence in the workplace. This then leaves the employer with angry clients and unnecessary additional costs. Understandably so, these employers look at dismissing these employees. However, dismissal is not always the appropriate sanction. In order to discipline the employee correctly, we need to first establish whether the misconduct amounts to negligence or gross negligence. Today, we will be discussing the difference between negligence and gross negligence and what the appropriate sanction should be if an employee is found guilty of such misconduct. And more importantly, whether an employee with a clear record, no previous warnings on file, should be dismissed for a first instant misconduct of this nature. I think, Simone, to start us off, can you define the terms negligence and gross negligence, please?
Thanks, Angie. So let's look at the two. So firstly, negligence can be defined as the culpable failure to exercise the degree of care expected of a reasonable person. For the purposes of today, a reasonable employee with the knowledge, experience, and qualifications compared to that of the accused employee. In other words, the carelessness or mere failure to exercise the degree of care as a reasonable employee would. Now, opposed to this is gross negligence, and a definition can be found in the case of NUMSA on behalf of Selepe versus Bergville Engine, which is a 2013 case, where the Commissioner defined gross negligence quite clearly as follows. It is the voluntary and conscious disregard of the need to use reasonable care, which has or is likely to cause foreseeable grave injury or damage to persons or property. So, Angie, the test is quite simple and consists of two elements. The first element being whether a reasonable employee in the position of the accused would have foreseen the possibility of harm or damage, and secondly, would have taken reasonable steps to avoid such harm or damage. So, Angie, perhaps you would like to elaborate further for us.
Thank you, Simone. Let's look at Grogan. He is a popular employment law author, and in his textbook titled Dismissal, 2nd edition, he states the following, that whilst in civil law, gross negligence has a technical meaning, in employment law, it can be seen as negligence which is particularly inexcusable. Now, usually for such misconduct, the sanction would vary between a final written warning and a dismissal. If we can show that there was gross negligence, meaning recklessness on the part of the employee, we could perhaps get away with a first instant dismissal. However, the onus ultimately rests with the employer to prove that the employment relationship has irreparably broken down as a result of the employee's recklessness. As with all dismissals, we still need to prove that the dismissal was substantively fair, meaning that good reason exists for the dismissal, and secondly, that the employer followed the correct procedure. Simone, I think it's also important to note here that the CCMA does still promote progressive discipline, and like with all misconducts, states that it should be reserved for severe misconduct. So if we can prove severe recklessness on the part of the employee, we could be able to justify a dismissal for such misconduct. I think based on that, let's look at the 2016 Robar case. Simone, if you could just briefly summarize that for us, please.
Sure. So the Robar case versus MBIBC and others, the facts of the case are as follows. The employee had committed 2 offenses. Firstly, he failed to pick up that employees were being paid for work which they had already been remunerated for. And secondly, he violated the company IT policy, which ultimately cost the company a loss of 42,000 Rand. Now, the arbitrator found that the sanction of dismissal was unfair, and the matter was then taken on review. On review, however, the judge disagreed with the arbitrator and stated that the arbitrator failed to properly consider the test, as we mentioned prior, and was misguided in his decision-making. Now, the facts of the case are that this employee, he basically, firstly, failed to exercise the degree of care as a reasonable employee in his position would, And secondly, he violated the company policy on numerous occasions. Now, the arbitrator made the comments that the employee had 30 years of experience and has also had no prior warnings, and that this, in comparison to a loss of 42,000 Rand, ultimately rendered the offense or the sanction as too harsh. Now, this is where we disagree. And the reasons that we disagree, and we agree with the judge, is that it's clear that this employee failed to exercise the degree of care expected of him and was blatantly disregarding company policy. And ultimately, this resulted in the employer-employee relationship being broken. So what's important here to note, Angie, is that when considering the offense, we need to isolate it and determine whether the employee was reckless or willful in his disregard of reasonable care. And secondly, it is not simply the act or the omission itself that determines the sanction of dismissal. It's the presence of a lack of diligence and care that accompanies it. So ultimately, when faced with making the appropriate decision, whether it be for negligence or gross negligence, it's very important and crucial to consider the facts of the case and the severity of the offense.
Yes, Simone, I think to recap on that and everything that we have said today, I think it is clear that we need to look at each case in isolation based on its own facts and then look at the degree of recklessness by the employee. In light of this, we would suggest that you contact your SEESA office when faced with misconduct of this nature in order for us to guide and advise you. Firstly, on what the appropriate charge would be, and secondly, to allow one of our legal advisors to chair the inquiry and establish whether the elements have been met.
So thank you for joining us, everybody. This is all we have time for today. If you have any further queries, please don't hesitate to contact your nearest SEESA branch or visit our SEESA website.